Good morning and welcome to the fifth meeting in 2014 of the Finance Committee of the Scottish Parliament. And could I first of all remind everyone present to please turn off any mobile phones or other electronic devices. And we have received apologies this morning from Malcolm Chisholm, MSP. Our first item of business this morning is to decide whether to take items 4, 5 and 6 in private. Are members agreed? Yes. Members have indicated their agreement. Our second item of business today is to take evidence from the Scottish Government Bill Team and Revenue Scotland as part of our scrutiny of the Revenue Scotland and Tax Powers Bill. I therefore would like to welcome to the meeting Colin Miller, Head of Revenue Scotland and Tax Powers Bill Team, John St Clair and Greg Walker, Scottish Government Legal Directorate, Nicky Harrison, Chief Operating Officer of Revenue Scotland. And I believe that Colin Miller would like to make a brief opening statement. Mr Miller.
Thank you, Convener. As you know, the Bill establishes Revenue Scotland as the tax authority with responsibility for the devolved taxes and puts in place a statutory framework for the collection and management of the devolved taxes. The Bill is introduced as structurally complete in the sense that there are no new issues to be added at stage 2. However, with a bill of this size and complexity, there's no doubt that there is scope for improving and refining the bill at stage 2. And with that in mind, we've been continuing to engage closely with the key stakeholder groups. We've recently had very helpful comments and suggestions from the Delegated Powers Committee. And we look forward to the evidence which the committee is taking during stage 1. We're very happy indeed to do whatever we can this morning to assist the committee.
Okay, well, thank you very much, Mr Miller, for that brief statement. I'll start off by asking you some questions, and I'll open up the session to colleagues around the table, and then we finish off with further questions towards the end of the session. We've been provided with quite a lot of financial information, as one would obviously expect. So some of the questions I'll ask, we actually have, to an extent, the answers for, but I think it's important to put some of these things on the record. And the first thing I want to start off with is costs to the Scottish Government in terms of financial memorandum. And I understand that the total for areas of cost remains at £16.7 million. The revised costs are directly comparable with HMRC's estimate for administering two like-for-like taxes to SDLT and LFT and continue to reflect the 25% saving originally identified by the Scottish Government. But I'm just wondering if you can detail for us how this 25% saving is achieved.
Can I ask Nicky to deal with that question?
Yes. The figures that are being compared in coming up with the number that's 25% cheaper is looking at a like-for-like comparison. When after the Scotland Act 2012, when Scottish ministers were first deciding how to go about delivering the devolved tax powers, one of the options would have been to ask HMRC to administer the taxes on their behalf. HMRC at that time gave an estimate of what it thought it would cost to deliver and administer taxes which were essentially similar to the existing non-devolved taxes, stamp duty, land tax and landfill tax. And that amount was put on the record at the time as being, I think it's 22.7 million. By contrast, Scottish ministers were able to estimate what it would cost were they to introduce and develop taxes themselves that were broadly similar to, the non-devolved taxes, stamp duty, land tax and landfill tax, and what it would cost to set up our own administration within Scottish Government for those devolved taxes. And that is the amount that is 16.7 million. So on a like-for-like basis, for taxes that are broadly similar to the non-devolved taxes, our estimate is still that the costs both for the set-up phase and for 5 years running, which is the basis on which the two estimates have been compared, there is a 25% reduction for Scottish Government administering the taxes compared to HMRC's estimate from 2012.
Thank you. However, of course, we have new activity estimated. I'm just wondering if you can talk us through those, because those come to some £3.51 million, including, for example, £1.5 million in IT and £610,000 for Revenue Scotland. So I'm just wondering if you can talk us through that extra £3.5 million.
Some of this is our estimates that are newly presented to you, but isn't necessarily new activity. So, for instance, one of the... excuse me, I'm sorry, forgive me for a minute while I just look at the table that you were looking at. I think, yes. So one of the, just to be sure of my numbers, so for instance, one of the costs that wasn't included in HMRC's original estimate was the cost of an appropriate tax tribunal to administer appeals or disputes on the taxes. So one of the items of difference that we are now making explicit in this financial memorandum is the cost of setting up and running a Scottish tax tribunal. That isn't really additional cost because it hadn't been estimated for by HMRC. So if we had decided to ask HMRC to administer these taxes, at this point they would be giving us an estimate of what it would cost to use a tax tribunal system. Some of the other is, though, as you say, additional costs that we are proposing. To take it in sequence from the table included in the financial memorandum, if that would be helpful.
Yep.
The first one for new activity is additional compliance activity. What we are proposing here, and this is an estimate of additional costs for just 1 year, that's for 2015-16, it is well documented that additional investment in compliance activity by revenue authorities can generate significant amounts of additional tax yield. And I think although that we have costed for an adequate and comparable amount of compliance activity in our baseline costs, I'm sure you'll be as aware as the rest of us of the additional investment that, for instance, HMRC has received in recent years to generate additional tax compliance yield. And we feel that that is something from which we could benefit. But we are proposing that amount for 1 year, and that would be closely monitored to see how much additional yield it would generate. We're confident it would more than recoup the costs invested, but are only proposing 1 year additional investment at the moment so that that could be reviewed. Next, the IT investment in Revenue Scotland. The previous financial memoranda have made it clear that the costs, the estimates did not include central IT development in Revenue Scotland, and nor did HMRC's like-for-like costs. Again, in view of our understanding, our developing understanding of the requirements to provide effective service to taxpayers and their agents and advisors, particularly for either complex transactions or to manage risk assessment activity and compliance effectively, it would be helpful to have a central data repository within Revenue Scotland. So our estimate at the moment is that that would cost £1 million to set up and £100,000 a year to run, which is where the £1.5 million comes from there. Previous memorandum have stated that the costs explicitly did not include an estimate for this, but that that would be reviewed. The Scottish Tax Tribunals, I've already covered that item. And then finally, the cost to the Scottish Environment Protection Agency for tackling illegal dumping. One of the big differences between the Scottish landfill tax and UK landfill tax is it permits a tax authority to tax illegal dumping. And that is a significant issue, both in environmental terms and in terms of criminal activity. But the UK tax authorities at the moment can't tax operators who are found to be illegally tipping. The Scottish Landfill Tax Act does permit that to be taxed. These are our estimates of what it would cost to most effectively tackle that. And again, that is for setting up and for running 5 years of tackling that illegal activity.
I think your answers have generated quite a few questions, and I can see some of the faces of colleagues around the table actually looking quizzical. So I'll ask a couple of those, and no doubt colleagues will ask further information in depth. I mean, first of all, in terms of compliance, I know when I read that modest additional investment compliance activity can generate significant increases in revenue, I wasn't really thinking that was just to cover the cost of the actual investment in the compliance and investigation activity. I'd have thought that I was actually going to ask you how much more than the investment, but you seem to mention that it's just really going to cover its costs. It makes one wonder why you're progressing with that, if that is the case. I understand that maybe if it's a one-off, there might be further benefits years down the line. So I wonder if you can clarify that. I want to ask you a couple of things, but I wonder if you can respond to that first, and then we'll go on to some other things that you talked about.
Yes. Sorry. I think in saying that it would at least cover the costs, I didn't wish to imply that we expect it only to cover the costs. So I apologise if I perhaps gave that impression. I think it is well documented that investment in compliance activity can often generate significant amounts of additional yield. I think, for instance, HMRC, in the additional funding it's received from Treasury for investment in compliance activity, generally works on a ratio of about 10 to 1, so a return of about 10 times the investment. We were quite cautious and prudent in the financial memorandum because we don't have a track record for the devolved taxes which would enable us to assess the size of the tax gap, and that's the thing that the additional investment in compliance would help to reduce. And nor do we have a track record to demonstrate the effectiveness of our compliance function. So apologies if I was being rather prudent in talking to you before, suggesting it would at least cover its costs. I think that if all it managed to do and all we aim to do would be to cover our costs, obviously that would not be an investment worth making. And I certainly wouldn't wish to suggest that. So I certainly would expect there to be a significant return on that investment. I think I was trying to reassure you that, at the very least, the cost would be covered. I think it's important that this sort of additional investment in compliance, we expect, would bring in significant additional yield, more than justifying the investment. We will do more work to try and understand exactly how much it will bring in. And that's partly why we've only suggested investment for 1 year, because as we work through that year, which would be in our second year our first year of operation, by the second year we'll be much clearer about the expected rate of return and can then be challenged in Revenue Scotland's performance as to what rate of return would be expected for the investment. I think it's also important to recognise that this sort of additional investment in compliance activity often can bring in additional yield in 2 ways. Part of that is a direct yield, so the actual cases we investigate, how much money will we bring in? But there's also the deterrent effect that is generated from that sort of activity. When it's clear that the Revenue Authority is really on top of its game in terms of identifying and tackling both evasion but also avoidance activity, then that can help to increase the voluntary compliance rates. And we would expect to be able to map our estimates of the impact of the investment on both those forms of additional yield.
Okay, thank you for that. Now, again, in terms of estimates for new activity, the £1,050,000 cost to SEPA, a processing and administering Scottish landfill tax from illegal dumping. I'm just wondering why that wasn't in the financial memorandum for that bill. I would have thought that would have been something that would have been integral to that bill of such a huge cost. And we were talking over £1 million here.
Yeah. I think some of this is that as it's become clearer with the passage of time, both what their powers will be to tackle illegal dumping, but also as we've become clearer about perhaps the extent of illegal dumping and realistically how much additional effort will be required to tackle that in terms of the pursuit of the attacks at risk. We have been able to update the figures for this financial memorandum. So, I mean, I don't think I can comment particularly on why that wasn't in the Scottish Landfill Tax financial memorandum, but much of this is, you know, in a spirit of being as open as possible. As our ideas have developed and as we've developed greater understanding of what could be involved in the administration of the devolved taxes, then clearly we wish to share those costs with you. And this financial memorandum has provided a helpful opportunity for that. And it's linked in a way to the same conceptual approach for the additional investment in compliance activity, which is that now that we know we have the ability to tackle illegal dumping, we can work out more clearly exactly how much investment would be needed to make that effective, both to counteract illegal tipping and also to effectively deter illegal tipping. And to remind you, that is over the 5-year period again.
Mm-hmm. I mean, similarly with the IT, I mean, you know, that wasn't obviously the financial memorandum of LVTT or landfill tax, and you're talking about £1 million plus £100,000 a year for 5 years.
Yes.
Again, I mean, surely this should have been anticipated, I would have thought. I mean, we're not talking a few £1,000 here or there.
No. I think, again, much of this is a reflection of where we have got to in our thinking about how best to administer the devolved taxes. The previous financial memoranda were quite explicit in stating that they did not include costs for a central IT system in Revenue Scotland. There were costs for IT, other than very minimal costs, for instance, for web page development. As we have worked through mapping out and developing our thoughts of what systems and processes would ideally be needed to produce the most seamless service for the taxpayer, to provide the best customer service, to provide the most effective risk assessment and compliance approaches, we have come to the understanding that actually a central, secure repository within Revenue Scotland, which could be accessed by the partner agencies, would be the best way of providing the requirements that we're now clear that we have. So I think this is a reflection of where we have come to in the progress of setting up the devolved taxes administration. And we've certainly got much deeper understanding now that we're so much further through the system than we had previously.
Okay, thank you for that. Now, Audit Scotland have made a brief submission, and they comment on the explanatory notes, which says that Revenue Scotland will have the status of a non-ministerial department. And they also go on to say that Revenue Scotland is expected to have the status of an office holder in the Scottish administration within the meaning of Section 126 of the Scotland Act 1998 by virtue of an order under that Act. In the absence of explicit provisions in the bill about accounting and auditing, it is important that the order is made and applies from the same date as the commencement of the date for the bill as a whole. And I'm just wondering if that is going to happen.
Yes, indeed, Convener. The point I'd like to make there is that, of course, precisely because office holders in the Scottish administration are defined in the Scotland Act 1998 and are therefore a reserved matter, that is why it's not possible to put that provision in this bill. However, we've been in touch with the Scotland Office, who in turn have been in touch with the relevant departments in the UK Government about the Section 104 order, and they have already agreed at ministerial level to bring forward a Section 104 order, which, amongst other things, will designate Revenue Scotland as an office holder in the Scottish administration. And as the Audit Scotland submission makes clear, that in turn triggers the relevant provisions of the Public Finance and Accountability Act 2000, and therefore the requirements for audits by Audit Scotland and accounts, of course.
Okay. Thank you for that clarification. I'm just going to ask one more question, and I'll open up to colleagues around the table. Our advisor, Professor McEwan, has produced an excellent paper, and I'll probably touch on that later, as indeed will colleagues. as we go forward. I just wanted to talk about Part 4 and Schedule 2, the Scottish Tax Tribunals. Professor McEwan has said that reading the bill, a striking contrast is that Revenue Scotland is set up in 11 sections and a schedule of 9 paragraphs, while setting up the tax tribunals takes 39 sections and a schedule of 42 paragraphs. I'm just wondering, that seems awful cumbersome and disproportionate. To explain why there's that kind of a apparent imbalance in terms of
Indeed, Convener. The issue here is the interaction between our bill and the devolved taxes which are coming into force on 1 April 2015 and the Tribunal Scotland bill, which, as you know, is currently going before Parliament and will establish a unified Scottish tribunal system, which in due course will take over the jurisdiction for all the existing devolved tribunals. And we envisage that that would include the tax jurisdiction. The problem is, although the Tribunals Bill is expected to complete its parliamentary passage this year, as I understand it, the first devolved tribunals will not transfer across into the new Tribunals for Scotland until the end of 2016 at the earliest. Whereas, of course, we need to be able to provide for appeals to be heard by an independent tribunal from 1 April 2015 onwards. So what we've done in Part 4 of this bill is essentially to replicate all of the corresponding provisions of the Tribunals Bill to create a self-standing two-tier tax tribunal in order to hear tax appeals for that interim period until the new Tribunals for Scotland is up and running. And when it is, the intention would be to transfer the jurisdiction of the tax tribunal and the members of the tax tribunal into the new unified tribunal. By going into the detail which we have, and as I say, consciously replicating the provisions in the Tribunal Scotland Bill, the intention is to make it as seamless as possible for that jurisdiction to transfer across into the new one with no adaptation or amendment necessary, hopefully somewhere around the end of 2016 or 2017.
Okay, well, thank you for that. That's been very helpful. I'm going to open out the session now to colleagues around the table. First person to ask questions will be Jamie.
Thank you, Convener. And I want to refer to Professor McEwan's briefing as well, if I may. And Professor McEwan identified that the extension of privilege in relation to information that was given by tax buyers and also accountants, which was extended to them, I think, in the Finance Act 2008, is proposed to be removed, but will remain for lawyers. And I'm just wondering if you could maybe set out what the thinking is here.
It's an interesting issue, and it's one that we've discussed with the professional bodies. Legal professional privilege is obviously very well established across the board, not simply in relation to the tax world, but generally. So I think it would be a starting point in relation to the powers that Revenue Scotland have to require information, that wouldn't interfere with legal professional privilege, and that is what the bill provides for. As you've said, the UK quite recently, in the Finance Act 2008, extended protection to tax advisors. And that was the expression used in the 2008 Act. Tax advisors were defined simply as anyone who provides tax advice. Now that is very wide indeed. It extends beyond those who have a recognised professional qualification or belong to a recognised professional group. It can literally be anyone who sort of sets themselves up to offer tax advice. And as we understand it, indeed the professional groups have told us, there are some fairly unscrupulous operators at the end of the spectrum. So in terms of judging where to strike the balance and where the public interest lies, what we've done is retain legal professional privilege, but we haven't followed the UK in extending that privilege to tax advisors.
So is your perspective there may be unscrupulous tax advisors but no unscrupulous lawyers then? I'm not really asking a comment on that. But I mean, I suppose it does get the question. I mean, can you clarify that a little further then? Is it your perspective really that this puts lawyers on the same footing? The their privilege is limited, so if the same information is required or that a tax advisor, whoever they may be, has provided, a lawyer that's provided similar advice, they would have to provide that advice as well under the provisions of the bill.
The tax advisor has no protection. Bear in mind that we're talking about protection in the context of information notices, which are which essentially Revenue Scotland issues, where they're seeking information in connection with tax compliance. So, I mean, quite clearly, the provisions in the bill relating to information notices are designed to sort of allow Revenue Scotland to engage in compliance activities. The question is what exceptions there should be. I don't think we could seek to intrude on the very well-established concept of legal professional privilege. So the issue really is whether there ought to be a further extension across the board for tax advisors. We very much understand the views that groups such as CIT and ICAS express. You know, there is no question that these are reputable organisations, and it's very easy to understand why they don't entirely see why they should not share in relation to tax the same protection or the same privilege that legal advisors have. The argument against that, and it's very much one which you might want to weigh yourselves, is where does the public interest lie? We've chosen to put the emphasis on effective compliance, and of course the provisions relating to information notices are themselves subject to safeguards.
Can I just dig into that a little further though, Mr Mills?
Yes.
The question was, under the powers set out, you know, it's not an absolute privilege that lawyers have. They can still be required to provide the same information that a tax advisor may be. That is correct?
No, I don't think so.
No.
I'll ask my legal colleagues to elaborate on this in a moment. But as things stand, as the bill is set out, communications between a lawyer and their client, legal communications, are protected, and therefore
Absolutely.
In the circumstances set out in the bill.
Okay.
So an information notice wouldn't bite on that. Revenue Scotland would not be able to issue to use the powers they have to issue information notices to obtain communications between a legal advisor and his client, but they would be able to obtain communications between a tax advisor and his or her client. But could I ask my legal colleagues to?
Yes, the section 130 2 says that for the purposes of this part, information or a document is privileged if it's information or a document in respect of which a claim of confidentiality of communication as between client and professional legal advisor could be maintained in legal proceedings. That's a very well-known, almost hallowed expression found in a great number of bits of legislation that enshrines this Scottish doctrine and English doctrine that there are certain communications between a lawyer and clients that you can't under any circumstances get. Now, we know that it's a difficult question where the material being communicated and in relation to the subject matter is exactly the same between a tax advisor and his client, why that shouldn't also be privileged in the same way that this is enshrined in statute. But that is not the case yet in England, and we know that the Supreme Court last year turned down the idea of extending it to accountants or other tax advisors and said it's up to Parliament to do it. So it is very much a policy decision, but it's one the Supreme Court was saying shouldn't be taken lightly because it may have unintended consequences of opening up this very important cornerstone of the Constitution.
So just to clarify that further, though, Mr Sinclair, you're saying that there are certain documents that a lawyer may hold. So is it every document that they may hold, or is it certain documents? That's the question I'm asking, I suppose. It's not. Is it an absolute level of privilege?
It's not every document.
That was really the question I was trying to establish. So
it's not every document. So the fee charging or something ancillary to what's going on, but it's when it's to do with legal advice in relation to a legal case.
So that's obviously a difference. So is there a degree of equivalence in terms of, even though the privilege it doesn't extend to tax advisors, whoever they may be, in terms of the type of documentation that a lawyer may hold that would be the equivalent of what a tax advisor provides? Yes. Is there a degree of equivalence?
Yeah, there could be if, for example, lawyers were selling avoidance schemes and promoting them, and tax advisors were selling or promoting avoidance schemes. These wouldn't be covered by the legal privilege because it hasn't become dealing with a client on the basis of giving legal advice.
That's very helpful. Of course, that begets the question then that could come into a matter of interpretation. So who will be the arbiter in any, and I'm presuming there'll be limited, hopefully there'll be none, but maybe there'll be limited cases whereby the tax authority says, well, we think that is something that we should look at, and the lawyer saying, well, no, absolutely isn't. Who will be the arbiter?
It would ultimately go to the tribunal, but the initial decision obviously would be taken by Revenue Scotland.
Okay. One final question, if I may, Convener, in relation to anti-avoidance measures. The advisor has suggested to us that it could be helpful to have, I don't know if this is the right term, but it's the only term that comes to mind, is some sort of general purpose clause whereby the tax authority, and if it becomes a matter for the courts, could interpret a matter looking at the will of Parliament in passing this bill. And I know that's not something that is routinely used, but is it something that's been looked at?
I think we have indeed got something along these lines, Mr Hepburn. If we can point you to section 59, subsection 2A1 and 2, which goes to the definition of artificiality. As you know, the central concept in the Scottish GAR as opposed to the UK GAR, one of the central concepts is the concept of artificiality. And what we've tried to do in section 59 is give clear pointers to what constitutes artificiality. Amongst these pointers are any principles on which the relevant provisions are based, whether expressed or implied, the policy objectives of these principles, and whether the arrangement is intended to exploit any shortcomings in these provisions. These are deliberately purposive tests, and what they would allow the Revenue Scotland and then the Tribunal and the courts to do is not just look to the sort of words on the face of a tax statute, because of course by definition avoidance activity is intended to try and get round those plain words. It will allow Revenue Scotland, the Court and Tribunal to look at the declared policy intention. And, for example, any statements which have been made in Parliament during the passage of the bill about what the tax legislation is or reliefs incorporated within it are designed to achieve. So I think we have gone rather further than previous attempts to sort of allow the Revenue Scotland to apply a sort of fairly purposive approach in taking counteraction under the GAR as set out in the bill.
Thank you, Mr Miller. That's helpful. Thank you. John.
Thank you. I mean, I suppose declaring interests, I should declare that I'm a member of ICAS, and I'm intrigued by the debate that just went on there between Mr Hepburn and yourselves, so I think I would like to just take it a little bit further. I mean, as I understand it, if it's specifically legal advice, which only a lawyer could give, that has a certain amount of protection around it, and I'm comfortable with that. I think we're then into the area of if it's specifically tax advice, which could equally well be given by a solicitor or an accountant or some other tax advisor. Have we got an even playing field? Because I suppose I'm hoping we have got an even playing field, because presumably it's not part of either Parliament's job to kind of favour one profession over another. And if it's Mrs Jones who's wanting a wee bit of tax advice about whatever, is it going to favour the fact that if she goes to her solicitor, it's going to be kept more secret, but if she goes to her accountant or somebody else, it's going to be more liable to come out into the open? So that's the area I'm interested in.
Could I offer two comments on that? And again, John might want to add something. In terms of Section 130, subsection 2, the bill does not distinguish between legal advice on the one hand and tax advice on the other. What it says is that an information or a document which Revenue Scotland would otherwise be able to obtain under an information notice is privileged if it's an information or a document in respect of which a claim of confidentiality could be made as between client and professional legal advisor. So, in other words, that goes to the sort of general principles relating to legal professional privilege. What we haven't done is to make a corresponding claim to privilege available to sort of tax advisors, however defined. And therefore, in those terms, you're perfectly right. There is not a level playing field between legal advisors and tax advisors. If we wanted to achieve a level playing field, that means we can do one of two things. Remove the privilege which extends to lawyers. And that would be, I think, a fairly extraordinary step, because legal professional privilege is very well recognised really across the board. Or extend that privilege to tax advisors, however defined. Now, if my concern...
Well, I mean, for simplicity's sake, I'd rather have things more open than more closed. Therefore, I would be thinking, could we take some of the privilege away from the solicitors, but still leave a bit there, the pure legal bit, or is it not possible to make that distinction?
John will tell me if I'm wrong, but I think the difficulty there is that legal professional privilege goes to the nature of the relationship between lawyer and client, not whether it's tax advice as opposed to family law advice or some such. So I think it would be very difficult to make inroads into legal professional privilege.
To be fair, I mean, solicitors, from my experience, have had to split up a lot of their advice over recent years because of financial regulations and things. So if they, for example, often do not now give advice about financial investments, which they used to. So it does seem possible to split up the advice you can get from a solicitor into different sections.
Although, if we went down that road, and I take your point that there are precedents for that in relation to financial services, that would still leave the question, should a similar watered-down protection be available to tax advisors, however defined as well? And my concern would still be, if you offer any form of privilege to tax advisors at large, and that really means anybody who purports to set themselves up to provide that sort of advice, then you are creating scope for abuse at the unscrupulous end of the spectrum.
Yeah, well, I mean, I have to... Mr Hepburn didn't press the point, but I mean, I think I would, that, you know, I do not have any more faith in solicitors than I do in other professions.
Yes, indeed.
And thank you. I realise I'm in a minority in Parliament, but anyway.
I think what...
no, I mean, I'm not suggesting for a minute that we give privilege to other people, actually. But it's more openness.
Well, I think we'd be very happy indeed if the committee was giving us a steer in this direction to go back and have another look at Section 130 and see whether it was possible to narrow the scope of the protection which is accorded to solicitors without driving a coach and horses through, you know, concepts which the legal profession and no doubt the judiciary are very attached to.
Yes, well, I mean, I'm pleased to have that kind of reassurance if you would have a look at it, because no, I don't think we want to drive a coach and horses through things, but I think, in one sense, this is quite an important piece of legislation, because we're going to set a precedent here, and potentially, you know, we're going to get other taxes somewhere along the line, and a lot of this is going to kind of fit into place. So if we're going to change it a bit, this would be the time to change it. But I'm not suggesting we throw everything out.
The steer you're giving us is a very helpful one, because curiously enough, the engagement we've had with stakeholders has been rather pushing us in the opposite direction. The professional groups such as ICAS and CIT are arguing essentially that they should have the same protection that the bill accords
to.
Yes,
yes, and hopefully you're reassured that I'm not speaking here for ICAS, therefore. Great, thank you. Right.
Could I ask my legal colleague just...
Sorry.
A little bit of clarification. When we were talking about slightly diluting the legal professional privilege, I did mention before that it was a sort of constitutional thing. Legal professional privilege is interwoven into European law, ECHR. So what we could do is, if it was helpful, moving in the direction that you obviously want, would be to delineate where the privilege didn't apply or where it did apply, and that might give a steer to people so that they realise it wasn't a complete blanket thing.
Well, certainly personally, I mean, I'd be very comfortable with that, but I can't speak for the rest of the committee, obviously. Thank you. Right, to go back to, again, something that somebody previously said, when the convener was questioning on the question of illegal dumping and the fact that we could have taxation on it in future, which we've not been able to have in the past. I mean, it may just be me, I'm struggling a wee bit to get my head around this, that, I mean, at the moment we find a huge amount of illegal dumping in Mr McMahon's constituency or elsewhere, and at the moment there's a fine and a penalty and people might go to prison and that kind of thing. And the only extra thing that would happen is we send them a tax bill. There would not be much cost then in sending that tax bill, would there?
I think, again, the point goes back to the one that Nikki raises, that the fact that we are now able to tax illegal dumping sort of provides SEPA, who are obviously engaged in this enforcement activity already, with a set of new tools. It doesn't mean they won't continue to prosecute people for the environmental offences, but they can now take action in conjunction with other agencies, for example, in large cases, the Crown Office Civil Recovery Unit, to recover what might be very large amounts of unpaid tax. But that does involve a cost, for example, in terms of litigation, court proceedings and so on. Right. I mean, just yesterday, there's a case for the Crown Office Civil Recovery Unit have recovered a very large amount in civil proceedings, but quite clearly at the end of a very long and expensive investigation and litigation process. But they did recover a large amount. Right,
so the kind of calculation of the tax and things should be quite straightforward. It will be
yes.
thereafter is the big problem.
It's securing, especially by definition, at the illegal end of the spectrum.
Right. Okay, to kind of go back to new points then, or start new points. One of the criticisms of HMRC has been that they seem to have had quite a lot of latitude to make concessions to taxpayers, and some people would argue to larger taxpayers, so they pursue small taxpayers quite thoroughly. But sometimes they kind of do a deal, and there was reference, that our advisor referred to, some of that came about, I think, through Fleet Street, when there was a change in the way people were paid, and it was accepted that the HMRC or Inland Revenue, as they would have been then, had a fair degree of flexibility. Could you just comment on where we're going with that degree, and I suppose it links into the openness of the internal advice that Revenue Scotland would have?
There's 2 or 3 points I'd like to make on that, and perhaps I could then ask Nikki to come in from a Revenue Scotland point of view. First of all, the intention is that Revenue Scotland will indeed prepare and publish guidance on the way in which it proposes to exercise the discretion which the bill provides it. And that is quite significant discretion, both in terms of taxes and penalties, for example. So the intention is that Revenue Scotland will be proactive in preparing and publishing guidance, including its own internal guidance to its staff and investigators. In terms of HMRC, I think it would be fair to say that the direction of travel in recent years has been quite similar. For example, the use that was quite extensive use, which was made of what were called extra statutory concessions, as I understand it, has gradually become more and more formalised, less the subject of open discretion and much more the subject of clear specific guidance. So I think your point is a fair one, but the direction in which HMRC is moving is probably where we'd like to start, which is to make sure that any discretion Revenue Scotland has is exercised in accordance with very clear published guidance.
Mm-hmm. Okay,
Nikki, is there anything you'd like to add to that?
No. I think that the heart of your question is probably going to the collection and management principle, which we have incorporated within the Revenue Scotland Tax Powers Bill. And that certainly has a long history of application and interpretation through litigation over the years from previous incarnation as care and management. And I think that collection and management principle is very helpful because in administering taxes, it is important to be able to apply judgment and discretion in certain circumstances. But you're quite right that that needs to be sufficiently open and curtailed so that the boundaries within which the discretion is exercised is very clear. So I think in terms of how that will look operationally, it will be important for Revenue Scotland to be open about its guidance to staff in how it administers the taxes and when it will be exercising discretion so that it strikes the appropriate balance between pursuing tax and being sufficiently forceful in doing that, counteracting non-compliance and evasion and avoidance, whilst not being unduly punitive in pursuing people who, for sometimes circumstances outside their control, the tax affairs perhaps aren't in order in the same, to the degree that we would expect it to be. I also think that perhaps part of this comes to the performance reporting of the organisation. And certainly we've already indicated, I think, to the in a written response to the Public Audit Committee, that Revenue Scotland will, of course, be quite open in reporting its performance in terms of pursuing tax, the amount of customer service standards, how effectively it deals with taxpayer transactions, how effective it is in tackling non-compliance, but also be open about the extent to which it exercises discretion in non-pursuit. So that will give an openness and a transparency, which I think, to be fair to HMRC, is something that they have done increasingly over the years.
Okay.
I wonder if I could just add one little bit of clarification. What Nikki said about we are incorporating the jurisprudence in relation to collection and management consciously, and that you mentioned the Fleet Street Casuals case. That wasn't quite an extra statutory concession. We are very aware of the recent jurisprudence that the HMRC and Revenue Scotland have got to be careful not to give concessions that Parliament hasn't intended. But that's a different issue to what arose in the Fleet Street Casuals, where the the court said you can let these people, don't pursue these workers in the Fleet Street because the chances of getting any money out of them are zero, and there are big political reasons why you shouldn't be pursuing them, which is to do with a discretion, not to do with an extra statutory concession.
Okay, well, thanks. That's helpful. I mean, I think that takes us into the Charter, which has been mentioned a few times. And I think we had some suggestion that perhaps was there a danger of the Charter being a bit one-sided, so it would kind of really emphasise the duties of the taxpayer, but perhaps wouldn't emphasise enough the duties of Revenue Scotland, and then would the reporting, which you just mentioned, would that be against the Charter and a kind of comparison made?
I think the point you make about sort of equality or even-handedness as between the tax authority on the one hand and the taxpayer on the other is a very good one. That was actually what we had in mind, but what we've realised in discussion with the stakeholders is the language used in Section 10, subsection 2, doesn't quite give that impression. It was intended to be effectively matching up, matching commitments. What it actually says is the Charter must include standards of behaviour and values which Revenue Scotland will aspire to, standards of behaviour and values which Revenue Scotland expects people to aspire to. The language hasn't quite, I think, has given an impression we didn't intend, which is, on the one hand, here's what Revenue Scotland will hope to do. On the other hand, here's what Revenue Scotland expects you, the taxpayer, to do. We will look at that with a view to bringing forward amendments at stage 2 to make it clear that it is even-handed. And on the one hand, the Charter will set out the standards of something about the standards of service which the taxpayer can expect of Revenue Scotland, as well as, if you like, the the other side of the coin. But it is intended, the Charter will be intended to focus on face both ways, and certainly Revenue Scotland will be expected to report performance against the Charter.
Okay, well, we'll look forward to seeing any amendments that come forward. Another question on wording is around the general anti-avoidance rule.
Yes.
And what has been called the double reasonableness test. One phrase that was used, tax arrangements are abusive if they are arrangements they entering into or carrying out of which cannot reasonably be regarded as a reasonable course of action.
Yes.
I think I've said before, I don't like using the word reasonable twice in the one sentence, but in one sense you could use it 3 times, because you could then bring in the concept of what a reasonable person would think. What was the thinking here in making it slightly different in
Yes.
this bill from UK legislation?
To be perfectly honest, Mr Mason, our thinking was exactly the same as yours, which is we're not entirely sure what Section 207, subsection 2 of the Finance Act 2013 actually means when it sets out the double reasonableness test. But it's certainly complex. What we've tried to do in designing the Scottish GAR in Part 5 of the bill is, 2 things. First of all, to go somewhat further than the UK has so far done in tackling artificiality as opposed to simply abuse. But secondly, to set out somewhat simpler tests. And one example of that is precisely the one that you've made. Our reasonableness test is just that. An entirely standard orthodox reasonableness test, and that's in Section 59, subsection 2. It's one of the tests of artificiality. If an arrangement is not a reasonable course of action in relation to the tax provisions in question, having regard to all the circumstances. And, as I mentioned earlier, the circumstances expressly include the more purposive tests, principles on which they're based, policy objectives. So we've consciously stepped away from the UK double reasonableness test, simply because it seems unnecessarily complicated, and it's not entirely sure, to me certainly, kind of what a double reasonableness test actually adds, and reasonableness in whose eyes.
And the very word reasonable is a word that the courts are comfortable
exactly.
dealing with in all sorts of legislation.
Absolutely.
Is that correct, yes?
Exactly. So, I think our reasonableness test is one that the courts and indeed lawyers would regard as a very standard one. Perhaps the thing that, again, the thing which is more novel in our GAR is the fact that we have attached somewhat purposive tests to the interpretation of reasonableness, but the reasonableness test in itself is entirely orthodox. I'm not aware of any precedents anywhere in UK legislation for the double reasonableness test, which the UK GARS has adopted, and that means essentially, I don't think anybody will be very clear what it means until jurisprudence emerges.
Okay, right, that's great. Thanks so much.
Thanks, John. Gavin?
To Mr Miller, like the treble reasonableness test is not going to get in at stage 2 of this bill, or indeed stage 3. Thank you. A couple of comments then. One on penalties. We've had sort of obviously briefings from stakeholders. There are 2 schools of thought. One is that penalties should be nailed down very precisely in primary legislation. The other view is you should put down as little as possible and then use regulation to outline penalties more clearly, where it's easier, obviously, to update numbers based on inflation and so on. Can you just give us, I guess, a bit of background as to how you've approached penalties within the bill?
That's a debate which we've been having with stakeholder groups, and it's also a point which the Delegated Powers Committee has picked up, and we've just very recently replied to them on that. I don't think the approach we adopted to penalties in the bill as introduced is entirely consistent. In general, we haven't specified amounts in the face of the bill, but there are a few examples where we have. In general, we haven't provided complete detail in the face of the bill about, if you like, the sort of box within which the penalty fits. we do accept that we need to look at that again in the light of the points which have been made. And indeed, in our response to the Delegated Powers Committee, we've given them an undertaking that will look to bring all the penalty amounts onto the face of the bill, and it will also look where, at the scope for bringing further detail about the sort of circumstances surrounding the penalty onto the face of the bill. We will still suggest to the Finance Committee at stage 2 that we should retain the order-making powers, because I think the ideal would be to provide clarity on the face of the bill so that everyone can see, you know, what are the sort of four corners of penalties and what are the amounts from 1 April next year, but also flexibility to sort of adjust in the light of experience, and that's where the sort of the order-making powers come in.
Okay, thank you. New subject then. In terms of the structure of Revenue Scotland, I think Schedule 1 to the bill, it sets that out. I think there are going to be between 5 and 9 members.
Yes.
And those members, there will be a chair appointed.
Yes.
Those members will then appoint a chief executive and so on. Can you, again, there appear to be two schools of thought. One is that the chief executive and other executives, if you like, ought to be members as such, so that you have a board of executive and non-executives, if I use those terms. Other school of thought is as you have laid out here, where the chief executive is not on the board, and there are 5 to 9 members and so on. Can you just, I guess, again, give us a background of the thought process of that structure?
Yes. And the issue here really is the arrangements for accountability, both within Revenue Scotland and as between Revenue Scotland and the Parliament. The structure we put in place is that the office holder in the Scottish administration is not a single person, but it's the collective, the members, and therefore the board. The thinking is in quite simple terms, the job of the board is to hold the executives, including the chief executive, to account. And in turn, the board is itself is accountable to Parliament. So that's quite a clear line of accountability. The danger is if the chief executive and perhaps other members of the executive team are themselves members of the board, then it becomes that much more difficult for the board to hold the chief executive to account. And indeed, particularly with a small board of sort of 5 to 9, if one or more of these members were executives, the danger is that you're placing rather too much sort of authority in the hands of the chief executive, who of course is also the accountable officer for Revenue Scotland. Having said that, there are different precedents. The Parliament has established 3 new statutory non-ministerial departments since devolution, and that's the Scottish Court Service, the Scottish Housing Regulator, and the Scottish Charters Regulator. It's fair to acknowledge that in relation to the Scottish Court Service, the Chief Executive is a member of the board, but that's a much larger board. It's 16. It's chaired by the Lord President, and I think half the members are judicial members. So I think it's fairly self-evident the Chief Executive alone on the board would not have a dominant voice. In relation to the other 2, the Scottish Housing Regulator and Charters Regulator, the model is exactly the same as set out in Schedule 1. The office holder is the board, and the Chief Executive is not to be a member of the board.
Okay, helpful, thank you. Okay, moving on then. Looking at the bill as a whole, in its entirety, is this bill and the organisations it sets up, is that being set up with an eye specifically on the 2 taxes that will be devolved in April of next year, or is it being set up with one eye on future taxes being devolved, potentially the whole lot or 1 or 2 more? There seems to be, again, amongst stakeholders that I've spoken to, there seem to be 2 schools of thought.
Yes.
Which is it, or is it a blend of the 2?
I think there's 2 things I'd like to say on that. First of all, every provision in this bill is necessary for the purpose of the 2 devolved taxes. And if that were not the case, then there would be a question as to whether provisions which didn't relate to either or both the devolved taxes were within devolved competence. But having said that, what we've also tried to do is to put in place a statutory framework for the collection and management of taxes, which can readily be adapted in the event of more devolved taxes, or indeed all taxes in the event of independence. As and when the Parliament acquires responsibility for further taxes, then we'd expect to have to bring forward further tax-specific bills, setting out effectively the rules relating to those particular taxes. But the intention would be to link each new tax to the framework set out in the Revenue Scotland and Tax Powers Bill, and we hope that that could be done with minimum modification. Any modifications that were required to reflect the peculiarities of individual taxes could be done in the tax-specific bill, but we have amendments to the RSTPB. But what we wouldn't need to do is put in place a new overarching framework. So I think the answer to the question, is it one or is the other, is that it's both. But we'd certainly have an eye to making sure that the framework which is being put in place in this bill is a framework which could be adapted in the event of more devolved taxes, just as the work which Nikki and her team are doing to establish Revenue Scotland is scalable. And that Revenue Scotland is an organisation which, while it will be responsible for 2 devolved taxes from day one, is also being established as the tax authority, which would be responsible for further devolved taxes or all taxes, should that materialise.
Okay, thank you. Slightly off the cuff question: do you need a GAR for 2 taxes?
Well, one of those taxes is land and buildings transaction tax, and the precursor tax, stamp duty, is one where there has been a great deal of avoidance activity. I think the point to make is the GAR, any GAR, is only one tool in an armoury of measures designed to combat tax avoidance. So, as the committee will know, having dealt with the Land and Buildings Transaction Tax Bill, which is now an Act, insofar as we can, that bill is designed to address known abuses, and that is by way of TARS, targeted anti-avoidance rules. But the nature of tax avoidance is that people will seek to get round the TARS and will seek to devise new avoidance measures. So the GAR and any GAR is designed, if you like, as a last line of defence. It's not specific to any particular tax, but it's designed to allow Revenue Scotland to take counteraction against avoidance activity generally. And the lesson of stamp duty land tax is that this is an area where there is indeed avoidance activity, and no doubt will continue to be, whatever our efforts to design it out of the LBTT.
Okay, thank you. The last thing I want to look on is just the financial memorandum, specifically around Revenue Scotland. I mean, the convener has asked some of the questions that were in my mind, but there are one or two others. The additional IT investment in Revenue Scotland, it's 1.5 million. $1 million, I think, is set-up costs, and then it's 100,000 a year for each of 5 years. I mean, is that something that genuinely wasn't envisaged when we got previous estimates? Because personally, I felt previous estimates were low. I mean, you were in tens of thousands for IT, which I think I and other members challenged at the time. But I certainly felt we were given assurances that everything was taken into account, and indeed there was a contingency, throughout the figures. So can you just give a bit more explanation as to how it's a lot bigger than it was?
I think to go back to the previous financial memoranda, you're right, they did include items for IT development, but were quite explicit in saying that the estimates did not include any amount for a central IT development in Revenue Scotland. And that a different design for the administration of the taxes might be chosen. So there were no costs included, and that was specifically excluded. As we have worked through over the last year, in first of all developing the 2 devolved taxes, but also working through the systems and processes, understanding what taxpayer service requirements there might be, understanding what different approaches we might take to meeting taxpayer and agent customer service standards, and approaches to risk assessment and approaches to compliance, we have very much come to the decision that a different design is needed, which would require a central data repository. So I think this is a reflection of where we have got to in having a much more detailed understanding now of the approach we want to take to administering the taxes. So it's very much a design decision rather than something that hadn't been considered previously. You know, I wouldn't really, you know, and so we've been quite explicit, including that in the financial memorandum, now that we're clearer about that design decision. And these are costs that would not have been in the original estimates from HMRC or the like-for-like estimates that were in the previous financial memoranda. I think much of the discussion we've had around, for instance, dealing with avoidance, dealing with evasion, you know, you can imagine that that has informed our views about what sort of a design do we need. And we certainly need a design that will enable ourselves and our delivery partners, Register Scotland and Scottish Environment Protection Agency, to readily be able to access and look up an individual taxpayer's record. And they could be quite complex taxpayers, involving different entities, different transactions over a period of time, and also to do much more sophisticated risk assessment, perhaps looking at patterns of behaviour by taxpayers, taxpayer groups, perhaps by the agent population. And for that, we feel that investment in a central data repository, an IT system, would be a much more effective way of enabling us to administer the taxes as efficiently as possible.
Okay. With this current estimate, then, is there anything, for the sake of the record, is there anything explicitly IT-related not included in that estimate, or is that the final figure?
That is our estimate at the moment. As with all estimates, it's our best estimate based on what we know at the moment. I don't think I can say that I have a crystal ball that it will exactly be that amount, but that is definitely our best estimate at the moment.
No, I wouldn't ask you to do the crystal ball.
Okay.
That's always risky. But I suppose my specific question, though, is there anything explicitly not included in there?
I see what you mean.
While in
right.
the, you know, it was stated in the memorandum,
Yep.
the impression I got from the previous discussion was that everything was included,
Yep.
and you're right,
Okay.
in black and white it does say that, but
Yeah.
is there anything explicitly excluded now?
No, there isn't.
Nothing?
No,
Okay.
no, there is nothing explicitly excluded. So that is our best estimate
Okay.
of what it will cost for the entirety.
Fine. Okay, thank you.
This is just a question for clarification. It's around section 144 in relation to information notices. It outlines in that, you know, the course of an appeal. Has this just been an adoption of the current practice, or is the refusal to allow an appeal beyond the tribunal something new that's been introduced into the bill?
My recollection is that there isn't any departure from the SDLT practice in relation to these provisions.
So it's not new.
It's not new, no.
Okay. That's fine, thanks.
Yeah, just on the question of avoidance, I think, when we took evidence before about looking at the charges for landfill tax, there was concern with people that it shouldn't be diverging from the same cost in England, because we were separating the tax. Taxing illegal dumping would make that difference, or is that something that HMRC are going to introduce themselves?
I think our approach in terms of taxing illegal dumping is new, and that clearly is designed to give an additional tool in relation to criminal activity. It doesn't bite on, sort of, by definition, on legal operators who are sort of working within the laws passed by Parliament.
Yes, but one of the points that was made was that should we charge slightly higher rate in Scotland as opposed to in England, that people might actually take their landfill to England and pay less. So by the same token, if somebody is going to illegally dump and they're not far from the border, what happens if they illegally dump in England?
I mean, I think in terms of sort of charging in Scotland, that's entirely a policy decision for ministers and for Parliament. In terms of whether the UK chooses to follow our approach to illegal dumping, obviously that's entirely a matter for the UK government and Parliament. I mean, I think it's fair to say that this is an area where consciously we've adopted a different policy from England and Wales, and part of that is certainly to sort of provide greater deterrence to those who engage in illegal dumping activity.
And criminals don't normally tend to factor in the level of fines or tax. They expect to not get caught. So it's probably a theoretical idea.
If we have, and SEPA do have greater success in compliance activity in relation to illegal operators, then, as I think we said earlier, hopefully, at the very least, that would be a deterrent to that activity. And the power to sort of tax, and for example, the Crown Office power, which they exercise in both civil and criminal proceedings to recover the proceeds of crime, these are very effective measures.
Thank you.
See, Jean, if only the mind of Ernst Stavro Blofeld. That has concluded questions from the committee, but I've got a couple of other questions just to ask, just to round things off. I was going to ask a number of questions based on the report from our tax advisor, but time really precludes that. But I do have one or two others. And first one is in terms of oral evidence taken with regard to LFT and given by Revenue Scotland. Revenue Scotland stated, and I quote, that there will need to be a formal agreement between Revenue Scotland and SEPA. The two organisations are already clear that we will need to develop that once the tax management bill is sufficiently far through its consideration. That should be a public document the committee will have an opportunity to scrutinise. It's just to try and find out when that's likely to be.
If I could just say one word and then pass over to Nicky, and that is to point out the requirement in the face of the bill in section 4 is for Revenue Scotland to publish and indeed to lay before Parliament the terms of any delegations to Revenue Scotland and then to ROS or SEPA, and also any directions which Revenue Scotland gives accompanying those delegations. Those will be formal, if you like, sort of almost legal documents. Just as you say, underneath that, there will be more detailed and more operationally orientated MOUs. And perhaps I could ask Nicky to say something about the timescale and the manner in which these are being developed.
Yes, just to explain the approach that we are adopting, working with Register of Scotland and with SEPA. We're very much working on the basis of mapping out taxpayer journeys to develop systems and processes for the administration of the taxes. And once we've got a clear view of the end-to-end processes, then assessing the relative strengths, if you like, of the different organisations involved to decide where the boundaries should lie in terms of the delegated functions. So, and I think we could have done it the other way round. We could have started off by saying the boundary will lie here and developed our systems and processes independently. But we feel that the value of the approach we're taking to tax administration has been to try and make the systems as efficient and as seamless as possible. And this is why we haven't yet got that clarity of where the boundaries will lie ultimately. However, we have certainly got working agreements, if you like, at the moment, as to where the boundaries are lie as we're working through the development and putting the systems in place. As we progress through 2014, those will become clearer and condensed into the documentation that will form the formal schedule of delegation that will be published as required under the Revenue Scotland Tax Powers Bill, and also linked to that memoranda of understanding that will operationally set that into an operational context, exactly what we are expecting in terms of service delivery by the organisations to whom we delegate functions.
And I think we can see that the intention would certainly be that these MOUs would be published, with the possible exception of anything which, which might assist someone who's trying to evade compliance activity.
Okay, thank you. And just one further point, which is in the joint 6-monthly progress report on the implementation of LBTT dated 4th of October 2013, Revenue Scotland and Registrars of Scotland stated that the result of this work will be a comprehensive catalogue of user interactions with a collection system, which in turn will be translated into system requirements. Now, as you will recall, during LBTT there was issues of concern raised about how ordinary members of the public would be able to interact with the system following its implementation. There was talk about help desks and the frustration in terms of dealing with HMRC, etc. So I'm just wondering if you can outline these in terms of how the public will be able to access the system where we are with this at the present time.
Yes, certainly. Amongst the streams of work that are being undertaken to develop the administration of the devolved taxes, there is a stream of work around customer contact. I use the word customer to encompass both taxpayers and their agents. So there is a stream of work where we are very clearly looking at understanding what users' requirements will be and how those requirements are best met, and understanding the importance of users' needs. So, for instance, with Land and Buildings Transaction Tax, largely being administered by solicitors as the intermediary for the taxpayer, one of the things we have been keen to do is to understand the processes from the solicitor's point of view so that we can provide a contact mechanism that most effectively meets their needs. We are still at the process of developing the requirements for that and making decisions within the governance framework for the programme as to quite how that is delivered. I'm quite sure that when they give the next 6-monthly update, Eleanor Emberson and John King and John Kenny will be quite happy to give you some more detail on that. But that is something that we are actively working on at the moment. And our focus is very much that contact for customers and their agents, it's important to get the contact opportunities right to meet their needs rather than it be driven by the bureaucratic needs of the organisation.
Okay. Well, thank you very much for that, and thank you very much for the comprehensive answers you've given today. Are there any further points you wish to make to committee at this point?
If I could just add one final word on the Charter, Convener. And I should have made this point earlier when one of the members was asking about the sort of balance. As you know, the provisions in the bill relating to the Charter require Revenue Scotland to prepare, publish and keep under review. The point's been made to us that what it doesn't expressly require Revenue Scotland to do is to consult both on the first Charter and in any revisions to it, and that's an amendment which we propose to bring forward at stage 2.
Well, thank you very much for that. That's very helpful. So thank you to colleagues for the questions, and thank you very much. I'm now going to close the session until 10:55 to allow a changeover of witnesses to give members a natural break. Thank you. I shall recommence the session. Our third item of business today is to take evidence from the Scottish Government Bill team on the supplementary financial memorandum that has been lodged for the Children and Young People Scotland Bill following amendments at stage 2. I would therefore like to welcome to the meeting Philip Rains, Acting Deputy Director, Children's Rights and Wellbeing Division, and Gordon Wales, Deputy Director, Finance Programme Management Division. So welcome to this morning's meeting, and just wondering if either of you have any statement or anything you'd like to make before we go to questions?
No, just to say that I'm very happy to answer the questions on the supplementary financial memorandum. As you know, the stage 3 debate on the bill is taking place this afternoon, so anything we can do to clarify the issues arising from the stage 2 amendments, we'd be very happy to do so now, or if not possible, from oral evidence, certainly afterwards. Thank you.
Okay, well, thank you very much. We'll go straight to questions. I'll ask initial questions, then, of course, colleagues around the table will ask theirs. I mean, I think some of the questions actually will relate to very directly to the financial revisions, for example. As you'll know, there have been significant revisions with additional costs going from £14.7 million in 2014-15 to £71.7 million. And the supplementary FM appears to reflect the costs associated with the expanded provision announced on 7th of January. But it doesn't appear to include the additional costs outlined in the letter of 12th September, which you may recall mentioned some £4.2 million being increased. So first of all, I just wonder if you can touch on that and give us a wee explanation on that, please.
Absolutely. The best way, I think, to distinguish is the letter of the 12th of September deals with funding issues, to do with, in a sense, how the bill for the early learning and childcare elements of the original financial memorandum, which of course have now changed because the supplementary financial memorandum will be picked up. They don't touch on the costs. The 12th of the letter of the 12th of September deals with two elements, as I recall. It deals with the cost, the funding for the, at the time, what was the vulnerable 2-year-olds that were going to be included in the extension of hours. And it was to deal with the costs, the element of the costs arising for the, what you might call the partner provider uprating, the element in which local authorities provide, negotiate funding for other organizations to provide the early learning and childcare. And what the letter basically set out is how that would be funded as a result of the budget discussions and negotiations. It doesn't touch the costs. So the costs for 2-year-olds, the costs for the partner provider uprating should not change and would not have changed as a result of that letter. How that would be funded, in a sense, the division, if you will, between local government and central government is what's being addressed as part of that letter. And with regard to the 2-year-olds, the letter set out that the entire provision for that cohort of 2-year-olds as set out in the original financial memorandum, that extension, would be paid for from an additional $4.5 million a year, some of which would be for 2014-15 incorporate the Early Years Change Fund, which operates up to the end of this financial year. And then there'd be an additional element to cover the difference, if you will, the inflationary uprating, if I can use that expression, between the partner provider floor, the national sum, the national figure that was used for calculating the funding between local authorities and private sector providers, which was last set in 2007, and what that figure might look like in currently as a result of inflation, which was set out in the original financial memorandum.
Okay. Thank you for that. You know, the original FM set out the childcare costs in 2011-12 prices, but the supplementary FM doesn't state what price basis has been used.
I can confirm it's the same.
It's the same. Okay,
yeah. Thank you very
much. I'm just wondering also why capital costs haven't been included in relation to the planned extension to the policy. States that it is not possible to provide an accurate estimate of the level of infrastructure investment required at this stage. But this contrasts with the approach taken in the original FM, where capital costs were included. Just wonder if you can explain why there's a wee bit of a difference in approach there.
Purely down to time. The stage 2, the timing between the conclusion of the stage 2 amendments and the point at which the supplementary financial memorandum had to be put in, there just wasn't enough time to be able to calculate those capital costs, which we recognise will be there. And we're in close discussion with COSLA and with ADES about what those costs will be. It also picks up, I think, the fact that the capital costs for this group of people, for this group of children, were not necessarily going to be the same as you'd expect for 3- and 4-year-olds. For 3- and 4-year-olds, you're talking about a more universal provision and therefore a different staff-child ratio. You're also maybe looking at more, if I might say, more standardized kind of service you might provide to those children through early learning and childcare. What you're looking at for the group of vulnerable 2-year-olds as part of the January announcement is some of them may have more significant needs. You're looking at different staff-child ratios. So the kind of capital costs you're going to be talking about are going to be quite different. And therefore, it's going to take time to be able to get the estimates in, to get to do the calculations and working through with CASA and ADES. And there just wasn't that time, unfortunately, within the window we had for providing this document.
So when will those figures be available?
I can't confirm now when they will be available. They'll need to be provided very quickly because clearly the commencement in August means that those costs will have to be developed very, very quickly. Again, I can provide additional information to the committee about the timescale, but perhaps as importantly, what those costs will be.
And who will be expected to meet those capital costs?
As with all additional costs arising from the Children and Young People Bill, as ministers have set out, it will be picked up, for local authorities, it will be picked up by the Scottish Government. So the understanding, and COSL understands this, that while we don't know exactly what those costs will be, the bill for those costs the additional costs will fall to the Scottish Government, as is the case with all the other early learning and childcare costs.
Okay, thanks very much. I'm keen to let colleagues in around the table, but I've just got one or two other wee points I want to ask. And one is about the amendment to eligibility for continuing care, where an estimated with estimated costs of 9.3 million by 2019-20 in Table 13 of the supplementary FM. But there's concerns being raised that there's a wide variation in the costs of the different types of care, that these haven't really been provided for, as no sensitivity analysis has been provided. And you'll be aware, obviously, that local government is suggesting that the costs may be up to twice as much as is being estimated, the estimate being some £3,142 compared to £6,000 on some local authorities. I'm just wondering if you can talk us through that a wee bit.
There are two separate points, and I'll take them in the order in which you raised them. In order to calculate the costs for those staying in care, you need to know what type of care they're going to be in. And that arises from, as you point out, Table 13 sets out the cost, but the share that we use for estimate is set out in Table 10. Mm-hmm. Now, those figures from Table 10 are taken from the official looked after children statistics. Basically, they're the most up-to-date statistics we have for, I think, the kids in 2011-12, when they left care. Where did they leave care from? Mm-hmm. Now, the reason we haven't looked at what those variations might be is because those statistics have remained relatively stable over years. We have no sense that the policy that we're pursuing would lead to a shift in those type of proportions. So a sensitivity analysis would make sense if we had good reason, good evidence to believe that historically the figures have shifted very significantly, or if they've done over recent time, or indeed if the policy was likely to lead to a significant shift in the way that children are set out between care. Indeed, if anything, anecdotally, our sense is in which residential care, the most expensive element, has probably been coming down. So if anything, by using those historical figures, we may well have underestimated. But we have to use the firm figures. So that's why we've used those proportions, and that's why they've applied as the assumptions. The second point you make, I think, is with regard to what you might call the unit cost, what it's going to cost. And that's a point that was set out in the original financial memorandum. I think the 3,142 figure is set out, I guess for the record, set out in paragraph 101 of the original financial memorandum. And as with all these kind of calculations, you've got to take evidence, you've got to take a view about how to make it up. But one of the components that make it up, and one of the components that was perhaps the most difficult to be able to get a consensus view on across the board, was around travel costs. And I know that some of those looking at the SPICE briefing, and COSL was citing the figure, I think, of £6,000 per person, which was coming out. That, I think, largely arose from COSL discussions with some local authorities that felt that some of the travel costs would be much more significant, and therefore what you'd be providing for every individual care leaver might be significantly more than we estimated. But I think, as we said before, I think with regard to the travel cost element, we feel that the higher figure doesn't represent an average across local authorities. It represents maybe the higher end of figures, which will undoubtedly be there for some rural areas, your Argylls and Buttes, your Highlands, what have you, but won't necessarily represent the costs you might expect in places like, which are not as large, where travel is easier, your Glasgow's, what have you. And therefore, the average cost we've taken out is the 3,142. And that's what, I guess, a long and short way, the short way of saying it is, the estimates that we've used for the supplementary financial memorandum are exactly the same estimates we used for the original calculations in the original financial memorandum, using exactly the same assumptions there.
Yes, I mean, the point, of course, was that 6,000 was considered more realistic by some local authorities, and I think you've actually addressed that point. But the issue is, with those local authorities who have these additional costs for geographic and other reasons, would that be taken into account in terms of how it would be funded?
I would hope so. As with all the way that the way these costs are worked out, they're obviously worked out at a global level, and particularly the funding that needs to go to local authorities, there'll need to be a distribution mechanism, and that applies as much to the aftercare, the continuing care elements, as it does to the early learning and childcare. And they're well understood, they're well established mechanisms and governance arrangements for doing that. I believe there's a distribution group that is operated by COSLA that will be working with the Scottish Government on how best to deal with that.
Thank you. One final point before I hand over to the Deputy Convener. Obviously, in terms of the evidence we took earlier on, the committee had some concerns about, for example, the issue of partners, partner providers, and we understand that it is, and I quote, entirely the responsibility of local authorities to decide what they pay partner providers, I think, which some of us were somewhat concerned about, given that some local authorities may not be as generous as others. But an additional £800,000 has been announced into this, and you did actually touch on partner providers earlier on. I'm just wondering if the Scottish Government's providing an extra £800,000, is there any guarantee at all that will actually be used as it's supposed to be in terms of providing for this?
In the sense of whether we have placed conditions upon the use of that money, whether we've ring-fenced that money, the Finance Committee will understand that's not the way we operate with regard to the relationship. So it's, I guess there'll be two parts, I guess, in answer. One is we're not treating that funding differently from the way that other similar types of funding are being treated. We expect local authorities to meet their obligations. We expect them to be able to get the adequate additional provision they should get from partner providers, and it's a matter for them. Having said that, there is, I think, a clear role for us to set out expectations in national guidance. We've clearly not taken a statutory role here, and I think that remains the case. But we clearly have a role, I think, in terms of how the funding, the provision should operate. And this has been obviously a very sensitive issue, and one that should be properly addressed as part of guidance. And as part of the development of that guidance, obviously we'll be dealing with the providers, but we clearly need to be bringing in the NDNA, yes, quite closely into the discussions as part of the development of the guidance. So that's something which will be, I believe, has already started and will be continuing forward.
I think all committee members are aware that there's no ring fencing, but I'm just wondering if through COSLA or others you've had any kind of almost gentleman's agreement that this money would be put where it's supposed to be put, because obviously, you know, the partnership providers are concerned about their own survival in some cases, let alone viability, and it must be deeply frustrating if we're providing additional money and the local authorities decide not to actually put it into those areas. So I'm just wondering if as a quid quo pro, the Scottish Government has in discussions with local authorities saying, well, we'll give you additional money, and we know, you know, that it's not in tablets of stone that will go into this, but we would expect an understanding that that's where it would be spent. Is there any kind of indication?
I'm not aware of those discussions. And to be honest, it'd be the sort of thing which it's probably best answered by COSLA about that. Because, I mean, at the end of the day, the local authorities and COSLA are the ones who, in a sense, need to account for how they are fulfilling their obligations and indeed their relationship with the providers who are the partners who are doing the provision.
Okay. Well, thank you very much for that. I now pass over to John, to be followed by Gavin.
Thank you. I don't have many questions, and it was really to follow up one of the areas that the convener touched on, which was the capital costs. And you know, I suppose I was a little bit uneasy with the questions. I mean, with the answers. Obviously happy with the questions. The supplementary financial memorandum says capital costs have not been explicitly estimated. Now, my understanding is they've not been estimated at all, so the word explicitly doesn't really mean anything. Is that correct?
I would say that they've probably their internal calculations that are going on. The work has been taking forward. People clearly can't be resting on their laurels and going forward. But explicitly, perhaps in the sense of being, in a sense in which we would be very happy to formally share these kind of estimates and costs because they've reached a point where we can verify them, I would say that's not the case. But the work is underway. It has to be underway.
Yeah, I mean, I'm relatively new. I've only been here for 3 years. I don't remember the situation where we were looking at this in the morning, we didn't have the figures, and the bill's due to be approved in the afternoon. Maybe that is common, I don't know. But, you know, really we're sitting here with a figure of nil, and we know it's going to be something, and we have no idea. I mean, could you even give us a range as to what kind of figures we might be talking about?
No, I wouldn't go as far as that.
Right, so it's going to be under 100 million.
Sorry, I just said I wouldn't go as far as that.
You wouldn't say it was under 100 million?
I would not say anything at all. I cannot provide those estimates. I can't provide those figures, I'm afraid.
And
all I
yet
can say is
have...
that we've shared these kind of works and calculations with CASA. We're working very closely with them. And you know, concerns have not been raised about the capital cost issues from the side against the people who've had to provide
Well,
it.
CASA aren't going to raise an issue if the government's going to pay for it, are they? So, I mean, that's fairly clear. I mean, effectively, the figure of nil has been put in. I mean, OK, there's a note saying the figure of nil is not going to be the figure.
I think there's a difference between putting no figure in and saying a figure of nil. Figure of nil suggests that we do think there is no cost. That is clearly not the case. We are just saying that at this stage, we're not in a position to be able to offer estimates. That's not the same as zero.
Well, I mean, I would argue that was a bit semantics, but I take your point that there is a slight difference there between not having a figure in and having a figure of nil in. But I just want to say publicly that I find this very unsatisfactory, that we're being asked to approve this, and we have not even a range of figures. Thank you, Convener.
Gavin.
Thanks. Just a couple of, I think, Convener and Deputy have used most of the queries I had. In terms of the, so you're not in a position to tell us the figure, I hear that. When you said the likely cost, or used the expression, I think it would be different, the per head cost would be different than the assumptions made per head for 3- and 4-year-olds. Yep. Without wanting to put words in your mouth, does different mean higher or lower? The impression I got was that it's probably higher per head because there are more specialised things needed and so on. Would that be fair to assume that it's likely to be higher per head as opposed to lower per head?
Yes, it is, indeed.
Yeah, okay,
I think if I can draw attention, I'm sorry, I made a note of this. One of the paragraphs in the original financial memorandum does set out the staff cost ratio, I believe, where this arose. Hang on a moment, I will get that. But the figure we have for the calculation, well, the staff cost ratio is 5 to 1.
So not so much for staff costs, but just in terms of the capital costs.
Well, the capital costs, that's different. The unit cost, I guess, is different. But for the capital costs, it's difficult to say because I'm not sure. A lot really depends on the way in which these kind of services are provided for vulnerable children anyway. So if it's a question of knowing what capacity is out there, how different local authorities have tackled it. Now, I would imagine when you're dealing with higher staff cost ratios and you need to maybe have a different set of provisions, the capital requirements could potentially be different. But how they would be different, I'm not in a position to say.
Okay, so just just to be clear on that point, I take the
point.
Sorry,
I misunderstood what you meant.
Sure.
But in terms of capital costs, I'm afraid I'm not in a position to be able to say whether if you will, the per child cost, or worked out, would be higher or lower than what we used for the original financial memorandum, which is 3- and 4-year-olds. So I'm afraid I'm not in a position.
Sure, no, just to be so when you did say higher, you basically meant the staffing cost per head would be higher.
Yeah.
Capital, you don't know.
Yes, that's true.
Right.
Yeah.
Okay.
Okay. Thank you.
Thanks.
Okay. Can we have a? Sorry, Jamie.
Thank you. No problem. Just returning to the issue of capital costs, and just to clarify a little further, I mean, there's a clear commitment here from the Scottish Government to meet the capital costs from the bill's provisions. I think Mr Rains made that pretty clear, and I'm not going to ask for a specific figure. I think Mr Rains actually quite fairly set out why that's not available at this time. But in terms of the early work, the work that's ongoing, the calculations that are underway, can you give a comment? The Scottish Government can meet these costs. This isn't going to bankrupt the nation.
I mean, if you're looking at the numbers of additional 2-year-olds we're talking about, it's well within, I think, the scope of, you know, it's not, I guess in that sense, significantly different from what was done for 3- and 4-year-olds. So the Scottish Government's been very clear that the additional costs that are the capital costs, the additional costs as a whole arising for early learning and childcare for local authorities will be met. So that commitment remains the same.
And just to clarify that again, this isn't placing a burden in meeting the costs in any other part of the public sector. The Scottish Government will meet these costs. Thank you.
Michael.
Thanks, Convener. When the original financial memorandum was brought forward, this committee raised a number of concerns about the the estimates and the assumptions that were contained within that financial memorandum. And I don't know what other members of the committee think, but I certainly haven't been assured by the answers that have been given in response to that financial memorandum report. And here we are, as John Mason said, on the morning of the bill, with additional costs being discussed, with additional funds being introduced into the financial memorandum. Could these additional costs and the mechanism by which they were scrutinised have come at a later date when the figures were available and that we could have seen greater clarity around these figures, or do they have to be included in today's proceedings?
Well, I'm not sure why today's session was scheduled today. I can't comment on that, I'm afraid. But the costs that are set out in the supplementary financial memorandum are largely arising from the Stage 2 amendments and the announcements that were made in January, which is what, barely 2 months ago, 6 weeks ago. So there's obviously been a very kind of shortened time, accelerated period of being able to work out these calculations. And we provided the supplementary financial memorandum as quick as could be as possible after the conclusion of Stage 2. Clearly, we can't put out the costs, and we can't set forward a supplementary financial memorandum until Stage 2 is completed. But as soon as it was completed, we did put together the work, quite intensive work in a very accelerated way to enable you to be able to consider these costs as quick as possible.
So it would have been possible for us not to actually be discussing this at the moment. This could have waited until after the bill had gone through, and then it could have come as a supplementary where we could have actually seen the figures. I mean, we're talking this morning about an addition to the financial memorandum based on amendments at Stage 2, which you say we only had 6 weeks to. How do we do it in any other circumstances then? That if amendments are made at Stage 2, we don't come back with supplementary financial memoranda each time that an amendment is put on a bill at Stage 2. So why are we doing it today?
I'd only draw attention to paragraph 3 of the briefing you received, which basically sets out under Rule 9.7.8b, which basically says how you deal with naturally what happens at Stage 2, which is changes are made to a bill, and it makes sense for Parliament to be able to consider what the implications of the cost implications of those changes are. And it sets out a time scale between the completion of Stage 2, because you can't tell people what the bill is going to cost now until Stage 2 has been completed, and producing, in a sense, our formal estimate of what those are. We met those timescales. We produced it as quick as possible. The document was provided to Parliament. Beyond that, I mean, the consideration by the committee, I think, is obviously an internal matter for yourselves, and the scheduling of today's evidence session is an internal matter for yourselves. But the supplementary financial memorandum was met within the existing timescales as set out by Parliament and as understood as a process for how bills are put together.
Okay.
So, in a sense, you may be asking wider, deeper questions that I can't answer because they're to do with parliamentary process, if you see what I mean.
There's partly that, but there's also the problem that we are here discussing it, whatever the time frame is. But you're telling us that you don't actually have the costs which are incurred by the amendments at Stage 2. So why are we discussing it when A, the timescale doesn't actually allow for the amendments to be properly scrutinised,
well, we do have,
and B, the costings don't you're telling us you can't give us figures up or down, you can't tell us what the capital costs will be, and yet we're expected to look at this, accept what you're putting forward, and then go into the debate this afternoon no wiser in terms of the changes that are actually being brought forward.
I think to be very clear, we have put out the costs for everything else except the capital costs. And admittedly, the capital costs are quite a complex thing, and we're not in a position to be able to provide that information. So yes, in that respect, you're true. I think it would probably not be fair to say we haven't provided costs. We have provided quite a lot of costs, and we probably have easily provided the lion's shares of the costs. I think if you look at the ratio between what capital costs were in the original financial memorandum, what that ratio was to the total costs of early learning and childcare, it was significant, but it wasn't probably the most significant element. I think the revenue element was probably the more significant one there.
Yeah, but what was significant about the earlier report was that we had major concerns about the costings that involved in that time, and there had been no attempt to amend or change those costs and no clarification around them. So,
well, no, that's not true. We did write on the 28th of October to the Education and Culture Committee, which set out a number of the issues that you, as a committee, set out to the Education Culture Committee in your note back to them, your report, if you will, and we responded in detail to those issues. So we have responded on those points.
Yeah, you have responded.
I mean, whether you're satisfied with them is another issue.
Well, that was the point I made there.
But I think it's not fair to say we haven't responded. We have responded in great detail to the comments that were made and that were passed to us by the Education and Culture Committee.
Okay. Michael, I hope to provide some clarification here. I mean, the supplementary financial memorandum was published on the 31st of January. We've obviously had a recess since then, so we didn't really have an opportunity to discuss this or take evidence on this really before today. And I took the decision that I thought it was more appropriate to have it today than a week after the actual passing of stage 3, so that we could get as much clarification as possible given the information that is available. And as Mr Rains has pointed out, that there is information except on the issue of capital. But just to give you some further information, I mean, supplementary financial memorandum is very unusual. It's only really because of the scale of this that we're doing this. Under Rule 9.78b of Standing Orders, it states, and I quote, "If a bill is amended at stage 2 so as to substantially alter any of the costs set out in the financial memorandum that accompanied the bill on introduction, the member in charge shall lodge with the clerk not later than the end of the second week before the week on which stage 3 is due to start a revised or supplementary financial memorandum." And that's what's happened. But I do have an issue in terms of Rule 9.3, actually, which I'm going to raise with Mr Rains. Under 9.3.2, it says, and I quote, "A bill shall in introduction be accompanied by a financial memorandum which shall set out the best estimates of the administrative, compliance and other costs to which the provisions of the bill would give rise, best estimates of the timescales over which such costs would be expected to arise, and an indication of the margins of uncertainty in such estimates." Now, that's obviously standing orders. I think the concern that the committee have, Mr Rains, is that we haven't had any real estimates in terms of these capital costs. There's not even a margin. It's not like between 10 and 50 million or 20 and 100 million. And I think that's the kind of frustration that the committee is expressing. And the standing orders makes clear that certainly, you know, we really should have that information, so that even if we're going into this afternoon's debate not knowing everything, and we understand you've explained to us why that's not the case, but we should have something, you know, we should have a ballpark figure, for want of a better phrase. Do you not agree? I mean, it was clear in standing orders.
I mean, there will be interpretation of that, but I don't think there's any interpretation. I think it's pretty straightforward. I mean, I've just read out standing order there, word for word. You know, an indication of the margins of uncertainty. There are no parameters, I think, in this capital cost, and I think that's the real issue. Within the timescale that we had to produce the supplementary financial memorandum, I don't think we were in a position to be able to provide those margins and those memoranda. That was, as you know, the 31st of January, a couple of weeks after the announcement was made. Now, we are now sitting at 19th of February, so the work has progressed since then. I apologise, I'm not in a position to be able to provide an oral update of where that's, what those parameters might be, but those parameters are, I would imagine, are beginning to emerge. So if you can't do it, if you can't provide those margins of uncertainty, then we can't address the question.
We'll have to deliberate on this further, but just to go back to something where I hope you'll be able to give us some answer, I just want to ask one further question, different from what we've been asking so far. It's just on kinship care. Just that, you know, There's a significant section in terms of the supplementary financial memorandum in terms of individual kinship care costs for guardians, but the paragraph 36 says overall there were no additional net costs in relation to kinship care in the original financial memorandum. This remains the case with these amendments, and yet that is on top of paragraph 35 saying in response to concerns about perceived lack of detail, Scottish Minister agreed to take amendments at stage 2 to provide for clear core eligibility tests for kinship care assistance in the face of the bill. From my own perspective, it just seems to me somewhat counterintuitive that there's no additional costs at all. I'm just wondering if you can talk us through why that might be the case.
Well, it's the same methodology as was applied to the calculation of this additional cohort that might be able to be eligible for kinship care was applied to this one. And as you'll know from the evidence, from the original financial memorandum and from the evidence we gave, our view was that this would lead to avoided costs. It would lead to, in effect, net savings. And that's same methodology has been set out, which is replicated, and the numbers that it produces are set out in tables 14 and 15. So, if you will, table 14 sets out, if you will, a gross cost, and table 15 sets out the avoided cost, and the avoided cost is larger than the gross cost. Therefore, our view is that, as with the original methodology for calculating kinship care in the financial memorandum, it would not lead to additional costs.
Because of this £3,000 margin, which is basically in between 14 and 15.
Yes. Yeah. But in principle, it's the same principle as was applied for the original financial memorandum.
I just really want to get that clarification on this. Okay. I'm just wondering if you get any further points you want to make to the committee. There doesn't seem to be any further questions from colleagues round the table. If there's anything else you would like to add at all?
No, but very happy to, as the further work is carried out, particularly with regard to capital costs, we'd be very keen and very happy to, at a suitable date for the committee, to provide that additional information as it's emerging, and to enable you to carry out your rightful role in being able to scrutinise the costs as it goes forward.
I'm pretty sure I speak on behalf of the committee to say that we would very much appreciate that to take evidence once these figures are available.
Okay.
But thank you very much for answering our questions today. That was very much appreciated. I'm now going to call another short recess to enable our witnesses and also the public and official report to leave as we're now going to private session.